The next topic of discussion is provision of Carrier Liability for ODC operator under Carriage by Road Act 2007. And to deliver this, ladies and gentlemen, please join me as I welcome to the stage the founder partner of CSL Chamber, Shri Sumeet Lall ji. We can have a louder round of applause, ladies and gentlemen.
Hi, good evening, everyone. I'm Sumeet Lall. I'm a founding partner of CSL Chambers. CSL Chambers is a Delhi-based law firm, and it's formed in association with Clyde & Co. Clyde & Co. has about 60 offices globally. It's one of the biggest insurance, reinsurance law firm, aviation, shipping, and international trade law firm in the world. So through that association, we have access to 60 offices worldwide and globally. First of all, I will then coming to the topic for discussion today, I'll be speaking on provision of carrier liability for ODC operators under the Carriage by Road Act. First of all, I would like to thank the association for inviting me to speak at this August gathering. To commensurate with their 15th anniversary. H2A, through its office bearers, has made some very significant initiatives and addressed issues of national importance to the central and the state government, including the Ministry of Road Transport and Highway, which has led to developments in the area of road transportation through hydraulic trailers. We've been making representation to the government from time to time, raising the concerns of the association member. Given my prior experience in liability claims arising out of varied carrier laws in India, I'm here to address and throw some light upon the limit of liability as stipulated under the Carriage by Road Act 2007. The Carriage by Road Act came into force on 1st March 2011, superseding the erstwhile Carriers Act of 1865. The Carriage by Road rules were also incorporated on the same day. Going back to the history, the earlier Consolidated Carriers Act was enacted on 14th February 1865, based on the UK's Carriers Act, which stipulated rights and liabilities of common carrier. Carriage of goods through any mode of transport, that is through land or inland waterways, was governed by this Carriage Act. However, with the sea change in the transportation sector, eventually this act was repealed and replaced with separate statutes for carriage of goods by different modes. Now, as to the carrier's liability, in the erstwhile Carriers Act, a carrier may be held liable for the loss or damage to the goods during the transit, owing to negligence or criminal acts of the carrier or its agent, wherein the carrier's liability was not limited and only subject to the declaration of value of the consignment being carried or special contract executed between the consignor and the carrier for limiting the liability. So earlier, the limitation of liability concept was not there. It was based on the contract that was signed between the parties. Then there was a need for a new isolated act. The need for enactment of 2000 Act, repealing the Carrier Act, also arose since most of the provisions of the Carrier Act had become redundant, obsolete. And as the transportation industry had changed radically over the years, and further other modes of transport came to be governed by separate statutes, incorporating internationally acclaimed rules and provision. Back in the day, there was a lot of legislative deliberation, including but not limited to Mr. P.C. Jain's recommendation in its report in September 1998, inter alia recommending a review of this act, followed by a report of the committee chaired by Shri M. Koteshwaran, the then Executive Director, Association of State Road Transport Undertaking that has also recommended the Carrier Act to be repealed. Even the Standing Committee on Transport, Tourism and Culture, while presenting its report to the Rajya Sabha in 2008, had taken into consideration the recommendation in Shri M. Koteshwaran's report. The bill which went to the Parliament at that time had a specific clause, and the specific clause had limited the liability of the carriers to 10,000 rupees only. This limit, however, there was a lot of debate, there was a lot of legislative debate on whether the limit should be restricted to 10,000 rupees or not. However, when the act was passed, this limit was given away. Now, there are various acts, as you can see on the slide, which governs carriers laws of different modes of transport. So carriage of goods by land, Carriage by Road Act, the Railway Act, carriage of goods by air, the Carriage by Air Act, the carriage of goods by sea, there are a number of enactments, and carriage by multimodal modes. Now coming to the object of the new Carriage by Road Act, the object of the act was to limit the liability for such loss or damage to the goods or property delivered by them to the carrier. So the entire purpose and the purport and the object was for amending the act was to regulate and limit the liability of the common carrier. It is evident the object of this enactment was to make common carrier liable for the loss or damage of goods carried by them and also limit the liability for such loss or damage to the goods property delivered by them to be carried. Even the statement and object and reasons included in the Carriage by Road Bill, when it was presented before the House of Parliament, promulgated, the intent is to regulate and limit the liability of the common carrier. Now, as opposed to the earlier act, the legislative deliberation, the new act included a limitation of liability clause, which stipulated the liability of a common carrier for a loss of or damage to any consignment to be limited to 10 times the freight paid or payable as per Rule 12 of the Carriage by Road rules, having regard to the value, freight, nature of goods, documents or articles of the consignment unless the consignor or any person duly authorized in that behalf expressly undertaken to pay higher risk rate fixed by the common carrier under Section 11. Now, Section 11, 10.2, Section 12, these are the important sections which form part of the new act. Section 10.2 provides that if there is any delay caused in the delivery up to the mutually agreed period, the liability is limited to the freight charged, or it can be superseded by a contract, which is a private contract between the parties. Under 12, a common carrier is liable to the consignor for the loss or damage to any consignment where such loss or damage has arisen on account of any criminal act of the common carrier or any of his servants or agents. The plaintiff does not bear the onus to prove such negligence or criminal act. They only have to allege that there has been a criminal act or there has been a negligence. Thus, the object of the 2000 Act was to create a balance between safeguarding the carrier's position by limiting their liability while also holding it responsible in case of negligence. The nature of disputes. Now, what are the nature of disputes that we are seeing, whether it's commercial in nature? So, normally, nature of these disputes are both termed as commercial disputes. They are also taken to the consumer courts. And then there are arbitrations where, based on the private contract between the parties, the matters go to the arbitration as well. Now, the difficulties for the hydraulic trailer operators. There is also a gray line when it comes to the definition of hydraulic trailers. Hydraulic trailers do not find, there is no definition as far as the Carriers Act is concerned. They are not a defined term. The common carriers are defined, but hydraulic trailers is not defined. So this is one thing which needs to be included in the definition of the proposal that has gone to the ministry. What follows is that in the event, if there is a loss of goods being carried on hydraulic trailer, liability computed in disputes not only exceeds 10 times of the freight, but is almost equivalent to the value of goods, thus putting the carriers back in a position before the 2000 Act was enacted. The purpose of 2000 Act was to limit the liability of the carrier. Given the fact that there is no defined rules, whenever there is a loss, the claim that comes for the loss is almost equivalent to the value of the goods, rather than 10 times of the freight value or other values. With the lack of level playing field amongst the parties, there are also instances where the consignor claiming total loss of his goods claims the entire amount to the consignment from the carrier. Even such loss would otherwise be partial loss. The Act does not define what is the total loss and does not make any distinction between the total loss and the partial loss. At times, what we have seen is even if the goods are repairable or goods can be sent back, the claims that come against the carriers is for the entire amount. What we have also witnessed is that most of the time the insurance companies settle these claims, and then you have a subrogated claim against the carrier, which is equivalent to the amount equivalent to the amount of the goods that it paid, and it does not leave or does not confine itself to the amount of claim that has been answered by the insurance companies. I'm mindful of the time, so I'll quickly say, based on our reading, based on our experience, what we've seen is there are certain suggestions which needs to be incorporated. One, the Carriage by Road Act identifies and defines modular hydraulic trailer. This is a recommendation that there should be a definition of modular hydraulic trailer. The limitation of liability in the event of loss or damage should be stipulated in the Act, limited on per unit weight based, on per unit weight basis, or any other form taking inference from other statutes like the Railway Act or the aviation, the airways, carriage by air, carriage by railways. The cost of statutory overheads to be excluded from the limit in place. So when you're evaluating the freight value includes number of permissions, permits, and other things that are taken. Then the limitation of liability should be separate for total loss or partial loss, and a maximum limit cap should be provided. Any other provision which the government thinks or which HDO is facing, then those should also be highlighted. The recommendation is that the government should put up a portal where the Hydraulic Association can put up their grievances. At least they should be heard for what their grievances are. With this, thank you so much. I'm mindful of the time. Thank you so much for having me over.
Sumeet sir, we would request you to please stay back on stage. Can we request Shri Mahendra Kataria ji to join us on stage and present a warmest token of appreciation to Mr. Lal.